This Constitution is a very unique document, and that this Constitution is supposed to be enforced, and I'm going to teach you some things here right now. This is a program, I don't know how it's coming out here. This right here is representation. I know it's kind of hard to see here, but basically what we're talking about here is this comes from the books that tell the judge how, right here and over here, this comes and tells the judge how the Constitution is to be interpreted. This is from the Am Jurisprudence volumes, and this is volume 16. You want the Constitutional Law section, right here, Constitutional Law, and you want section 97. And when you start reading it, the most important part about it, and I'll read it, is that a Constitution should receive a liberal interpretation in favor of the citizen is especially true with respect to those provisions which were designed to safeguard the liberty and security of the citizen in regard to both person and property. Can you see that? Can you all see that? Is that coming up right here? Over more. Okay. All right. To safeguard the liberty and security of the citizen in regard to both person and property. See note 31, Breyers v. United States, 273 U.S. 28, and all of these 40 Supreme Court cases hold that axiom.
Hit that like, guys.
In other words, it's supposed to be liberally enforced in favor of the citizen for the protection of rights and property. And a constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. 32. Go down 32, DeJammer versus Hospital Authority of Albany, in all of these cases. Okay, you can see that? All right, help you out here. Okay, is it in? All right. I'm just trying to tell you.
Jack up, Jack. Thanks, man.
Better see it. Can you see it?
Good to see you here, guys.
Okay. All right, now, let's do that over again. And a constitutional provision intended to confer a benefit should be liberally construed in favor of the clearly intended and expressly designated beneficiary. Similarly, a provision intended to afford a remedy to those who have just claims should receive a beneficial.
All right, guys. What this is American jurisprudence, and what he's telling you is that this is the books that tell the judges how to interpret the law and how it's supposed to be interpreted in favor of the citizens. All right, and he's going down it right now.
Construction for the purpose of extending the remedy to all who might fairly come within the meaning of the terms, and that's Ryder versus Fitchie of Ohio, a Supreme Court case, okay? That's note number 33, okay? Now, this comes out of 16th Am Jurisprudence. In other words, I have this Constitution. This Constitution is a contract in writing enforceable in court of law pursuant to the statute of frauds. I'm asking for specific performance, Your Honor, in favor of me. I am the beneficiary of the contract. There's also a basic premise in contract law, Basic Contract Law 101 of any first-year law student, that says the contract shall be enforced most favorably in favor of the non-preparer. And that's you. You didn't prepare. Now, if you believe honestly that you have a right...
What's up? Keeping the swine in line.
Bring that right before a proper adjudicated authority, and you can clearly stipulate as to what your right was. Guess what? They got to listen. That's the way it is. That's the way it's supposed to be. And I'm telling you, if you know...
All right, who else is in here? Go ahead and press that thumbs up, guys. I appreciate it. This is real informational, real educational. Something that gives you an idea of how to enforce your rights, how to stand for your rights. All right?
Your rights, and you timely assert those rights, you have those rights. But if you sit on your haunches and you cry foul, that's terrible. Somebody ought to do something about that. Hey, be a somebody. Do something about it. Don't sit there telling me that somebody ought to do something about that. Be a somebody. You do something about it. You honestly got an honest bitch, you go out there and you take care of it. Because that's what it takes to be an American. That's what it's all about. That's what being an American is all about. That's what separates you from the rest of the whole world. Because Americans, you don't trample on their rights because they're going to come get you. You do not trample on their rights. They won't put up with it. So be an American and don't put up with it. Stand up there and be counted. Now I want to read the next argument there, which is argument number 98, which basically deals with the effect of an emergency. Argument 98. Does everybody see that there? Get it there? Pretty good? Alright, argument 98. While an emergency cannot create power and no emergency justifies the violation of any of the provisions of the United States Constitution or state constitutions, public emergencies such as economic depression, alright? Go over here to the next page. What happened here? Alright, let's go. For especially liberal construction of constitutional powers, and it has been declared that because of national exigency, it is the policy of the courts in times of national peril so liberally to construe the special powers vested in the chief executive as to sustain and effectuate the purpose thereof, and to that end also more liberally to construe the constituted division and classification of the powers
Modern
of the
Retro
coordinate
Radio.
branches of the government, and insofar as
Good
may
to see you
not
guys
be clearly
here.
inconsistent with the Constitution, right? In other words, they can't be in conflict with the Constitution to vest extraordinary powers in the chief executive. But I'm telling you, on the other hand, a contention that a grave emergency, such as the Depression, should permit construction of the constitutional provisions which would meet the emergency was rejected. In one case, the court holding that neither the legislature nor any executive or judicial officer may disregard the provisions of the Constitution in cases of an emergency, where the plain and unequivocal terms of the Constitution present to question of construction as to departures in emergencies. So not even an emergency justifies the taking away of constitutional provisions. And I know you've heard differently. I know you think, well, they got an emergency. They just declared an emergency, and then the president issues an executive order. But let me ask you, if it's in repugnant with
Emergencies such as maybe the VAXX, trying to make people wear masks, trying to force people to get that jab. You know what I'm talking about? These crazy emergencies to try to control the people, try to control you, try to control just the general public everywhere. But this tells the judges, or tells, the courts, that an emergency can be a reason to be holding down your rights, to be depriving you of those rights.
Constitution of the United States, is it law? No. Who says so? We do. We're the people. It's our country. It's our Constitution. We're the taking away of constitutional provisions. And I know you've heard differently. I know you think, well, they got an emergency. They just declared an emergency, and then the president issues an executive order. But let me ask you, if it's in repugnant with the Constitution of the United States, is it law?
Stopwatch.
No.
Good evening, man.
Who says so? We do. We're the people. It's our country. It's our Constitution. We're the ones that say you can't do that. And we mean it. You better listen. Alright, now, let's get into the next argument here. Now, I hope I'm not boring you to tears here, but it's kind of important that we cover these basic things so that you can understand. As to the construction with reference to the common law, an important canon of construction is that constitutions must be construed with reference to the common law. That means the law of the little people out there, not the corporations. Okay? Since it, in most respects, the federal and state...
To the common law, meaning the common law, not statutes, not ordinances, not policies, but the common law.
Constitutions did not repudiate, but cherished the established common law. This fact has been taken into consideration by the courts in construing certain clauses in a state constitution, such as the provision securing the right to a jury trial. Also, provisions in regard to crimes have been interpreted with reference to the common law rule that one charged with a crime may be convicted of a lesser offense necessarily included in the crime charged. In such cases, the courts of the state always regard the language in the common law sense. So the common law prevails. Don't let anybody tell you this admiralty law prevails, because it only prevails if you get sucked into it. We're not going to let you do that. We're going to teach you how to beat it. The common law also permitted destruction of the abatement of nuisances by summary proceedings. Traffic tickets, folks. That's what a traffic ticket does. It is a writ of assistance, a bill of attainder. It's unlawful in the United States of America. And it was never supposed that a constitutional provision was intended to interfere with this established principle. And although there is no common law of the United States in the sense, who said so? Erie Railroad versus Tompkins. Okay? All right? Of a national customary law as distinguished from the common law of England, adopted in the several states. In interpreting the federal
Hold on,
constitution,
guys. Let me take this phone call.
recourse may still be had to the aid of the common law of England. It has been said that without reference to this common law, the language of the federal constitution could not be understood. So the common law applies, folks. And we're going to get into that common law heavily in the advanced section, all right? Okay. Now let's get back into this. In interpreting the federal constitution adopted by the several states, all right, the recourse may still be had to the aid of the common law of England. It has been said that without reference to the common law, the language of the United States Constitution would not be understood. This is due to the fact that this instrument and the plan of government of the United States were founded on the common law as established in England at the time of the Revolution. Okay? Therefore, it is the general rule that the phrases in the Bill of Rights taken from the common law must be construed in reference to the latter. Specifically, the United States Supreme Court has taken the common law into consideration in construing the Fourth Amendment, the Fifth Amendment provisions relating. All right? So the common law is extremely important that we get, and we will cover that thoroughly. It's important to understand that most of you out there are citizens at the common law. That only those that understand the differences in admiralty and maritime law, those that are corporations, officers of corporations, or officers of government residing in the District of Columbia, the 14th Amendment duality of citizenship, which is talked about in the case of Erie Railroad versus Tompkins, which is a rather heavy argument. And I will cover that thoroughly with you so that you understand where the traps and the differences are. But for right now, I'm trying to demonstrate to you construction and programming so that you can understand that this Constitution right here is the supreme.
All right, Tapatios. You can get this in the law library, or you can order it maybe in Amazon, but it's American Jurisprudence, the 16th volume. All right, that's where he's getting all that information from. That's from American Jurisprudence.
Law of the land. It is a contract in writing. It is enforceable in favor of you. In an open court of law, you are the beneficiary. Okay? I want to give you some basic more points on this Am Jurisprudence argument. This is section 114 of the 16th volume of Am Jurisprudence second. I'm going to give you a couple more of these sites so that you can understand how powerful a document this is. Okay? Let's go to the next section, which is 115, which is, let's see, which one? 117. 117 is the next serious section. They're all serious. By the way, I highly recommend you go down to the law library, grab that 16th volume Am Jurisprudence, start at section 1 and start paging through to section 300. You will absolutely be astounded. We are now in 16th Am Jurisprudence, section 117. And I will read it to you. Basically, various facts and circumstances extrinsic to the Constitution are often resorted to by the courts to aid them in determining its meaning. As previously noted, however, such extrinsic aids may not be resorted to where the provision in the question is clear and unambiguous. In such a case, the courts must apply the terms of the Constitution as written, and they are not at liberty to search for meanings beyond the instrument, which that militia argument and that collective law theory of the Second Amendment is. They're reaching far. All right? Clearly it says in the plain English, the right of the people to keep and carry arms shall not be infringed. Now, what is it you don't understand about the word infringed? They're infringing. The Brady Bill, it's infringement. 1968 Gun Control Act, it's infringing. All of these, the CCW acts of these states, they're infringing. Who says so? You do. How shall a document be enforced in favor of who? You.
You.
When are you going to enforce it? You're the one that is the citizen. All power is inherent in the people. You're the one with the power. Enforce your power, all right? Does everybody understand that argument? That's the magnificence. I'm bringing the genie out. We're stroking the bottle here. And I'm going to bring the genie out here in a second. You're going to understand the magnificence of the power of this book.
This is good stuff, guys.
You see, once you understand this
he's
is an
telling
ironclad
you.
contract, once you understand that this is enforceable in the court of law pursuant to the statute of frauds, once you understand you have a right to claim specific
just
performance on
to
the contract.
know your
Your
rights,
Honor, demand my
but
right
how
to keep
to
and carry arms.
enforce
That
them and
right shall
stand
not
on
be
them.
infringed. I want specific performance. I am the holder of the contract. It's supposed to be enforced in favor of me. I am the clearly intended and expressly designated beneficiary, the citizen. I want the thing protected in favor of my right. Does that make logical sense to you? Now do you start to understand the power of this document? Okay? See, before, you just thought it was a bunch of writing in some textbook that you had to take when you took a civics class in high school in the 11th grade. See, I want you to understand that you don't leave home without this. This is more important than your credit card. Okay? Next, let's get into the next section. I'm going to cover some more of these am jurisprudence sections so that you can understand. I want to get into section 155. 16th am jurisprudence, second section 155. Since the Constitution is intended for the observance of the judiciary as well as other departments of government, and the judges are sworn to support its provisions, got me? Sworn, as an oath of office, sworn. The courts are not at liberty to overlook or disregard its commands or countenance evasion.
And you see, that's what the courts are doing nowadays. They're just disregarding the Constitution because you're not in the main court. You're in the municipal court. That's like an administrative way to handle things that they like to call crimes. For instance, the speeding ordinances, stuff like that. That's what municipal courts are for upholding and enforcing policies and stuff of that sort. But that's what the courts are doing. They've set up this lower court, but we have to go to the higher courts. Always appeal. You go to court, you lose it, appeal. Keep on fighting.
Thereof. It is their duty in authorized proceedings to give full effect to the existing Constitution and to obey all constitutional provisions, irrespective of their opinion as to the wisdom or the desirability of such provisions, and irrespective of the consequences. Thus it is said that the courts should be and are alert to enforce the provisions of the United States Constitution and guard against their infringement by legislative fiat or otherwise. In accordance with these basic principles, the rule is fixed that the duty in the proper case to declare a law unconstitutional cannot be declined and must be performed in accordance with the deliberate judgment of the tribunal before which the validity of the enactment is directly drawn into question. If the Constitution prescribes one rule and the statute another, and a different rule, it is the duty of the courts to declare that the Constitution and not the statute governs in cases before them for judgment. Does everybody understand that? They're telling the judge, you got to rule in favor of the Constitution. And if you know your Constitution,
What's up, Four Corners?
whose favor are they going to rule in? Yours. But you have to have enough hair on your tail feather to walk in there and say, hey, I'm an American. And I have a constitutional right. That right shall not be infringed. And you're infringing. And I'm asking you not to do that because it's not nice. And I'm asking the judge to do his duty under his sworn oath of office and uphold the United States Constitution as he swore he would under Article 11, Paragraph 1 in this state, which says that he shall swear to protect and defend the Constitution from all enemies, foreign and domestic, and he will perform his duties to the best of his ability, so help him God. Now, let's get closer to so help him God. Now, let's get into another one of these. We got a load of them, folks, so let's bear with me here. 16th am jurisprudence, second section 177. Declaratory judgments. Declaratory judgment actions have often been utilized to test the constitutionality of a statute and government practices. The Uniform Declaratory Judgments Act makes specific provisions of the determination of construction or validity of statutes and municipal ordinance by declaratory judgment, and is considered to furnish a particularly appropriate method for the determination of controversies relative to the construction and validity of the statutes and of ordinances. The Federal Declaratory Judgment Act, although it does not mention declarations as to the construction or validity of the statutes, has been invoked frequently as a means of assaying the constitutionality of congressional legislation. A plaintiff can have a declaratory judgment action on the constitutionality of either the federal or state statute by a single federal judge, so long as he does not ask to have the operation of the statute enjoined. You can't enjoin a constitutional right. A court may grant declaratory relief unless there is a case of controversy before the court. That is, the dispute must consist of specific adverse claims based upon present rather than future or speculative facts on which to base the adjudication. All right? Now, I'm trying to tell you folks here, you have a right to demand a declaratory judgment, which we are going to do in several of our cases here. And they got to declare it. Is it constitutional or isn't it constitutional? If it's constitutional, it has to be judged in favor of who? You, the citizen. Why? Because you're the beneficiary. It's supposed to be enforced in favor of you, the beneficiary, the citizen, for the protection of rights and property. See Byers v. United States, 273 U.S. 28. And the 40 Supreme Court cases that support that mandate. Okay? Now let's get, there's just a couple more here, bear with me. I know you're probably bored to tears right now, but I don't want you to do that. I want you to pay attention. Okay, we're at section 255. 16th Am Jurisprudence, section 255. In all instances where the court exercises its power to invalidate legislation on constitutional grounds, the conflict of the statute with the Constitution must be irreconcilable. The Brady Bill. Irreconcilable. Huh? In other words, the court is without authority to declare a statute unconstitutional unless it is in positive or direct conflict with the statute or with the Constitution. Thus, a statute is not to be declared unconstitutional unless so inconsistent with the Constitution that it cannot be enforced without a violation thereof. Because that would be violating the Constitution. We can't have that. What happened in Marbury v. Madison, 5 U.S. 137, same thing. A clear incompatibility between
Susan,
law and
thanks for showing up.
must exist before the judiciary is justified in holding the law unconstitutional. This principle is, of course, in line with the rule
This is
that
good
doubts
information.
of the constitutionality should be resolved in favor of the constitutionality and the beneficiary, you, the citizen, for the protection of your rights and property. Okay? Does everybody pick up on that? Now let's shift to 256. 256. Right here. The general rule is that an unconstitutional statute, whether federal or state, though having the form and name of law, is in reality no law, but is wholly void.
Now, I've done a video on this myself where I went to the law library and looked up this information and showed it. There's a video that I done and it shows the same thing, you know what I mean? It's written different. It's written a little differently on some parts. You can see how the way they're trying to slowly cover the meaning of the original meanings by, you know, rewriting, you know, the books and stuff and making it a little more ambiguous. But listen to this. It's good stuff. I done a video on it myself when I went to the law library.
And ineffective for any purpose, since unconstitutionality dates from the time of the enactment and not from the date of the decision so branding it. Wouldn't it be interesting if 34, verse 34?
Yeah, I need to put my Constitution, carry my Constitution with me in a paper bag.
Here's 35, all right, here's 34. State ex rel versus Nguyen v. Greer. But I'll tell you what, Marbury versus Madison comes higher than that, okay? All right, 34.
What up, money? What up, money?
Ineffective for any purpose. Since the unconstitutionality dates from the time of the enactment and not merely from the date of the decision so branding it. An unconstitutional law in legal contemplation is as inoperative as if it never had been passed, the Brady Bill. the crime bill, the 1968 gun control bill, all these bills. Such a statute leaves the question that it purports to settle just as it would be had the statute not ever been enacted. Right? Let's go on. No repeal of an enactment is necessary. Since an unconstitutional law is void, the general principle follows that it imposes no duties, confers no rights, creates no office, bestows no power or authority on anyone.
Are you looking to establish your business using an address other than your home? Well, at iPostal...
Oops. I don't know what happened there, guys. Hold on.
Good afternoon. Some of you.
Anyone affords no protection and justifies no acts performed under it. A contract, let's go on.
Let's listen to
No
that again.
repeal.
Listen to this. This is important.
No repeal of an enactment is necessary. Since an unconstitutional law is void, the general principle follows that it imposes no duties, confers no rights, creates no office, bestows no power or authority on anyone, affords no protection, and justifies no acts performed under it. A contract, did everybody pick up on that keyword, contract? A contract which rests on an unconstitutional statute creates no obligation to be impaired by subsequent legislation. No one is bound to obey an unconstitutional law, and no courts are bound to enforce it. Persons convicted and fined under a statute subsequently held unconstitutional may recover the fines paid. A void act cannot be legally inconsistent with a valid one, and an unconstitutional law cannot operate to supersede an existing valid law. Indeed, insofar as a statute runs counter to the fundamental law of the land,
They're trying to be your daddy.
superseded thereby. Since an unconstitutional statute cannot repeal or in any way affect an existing one, if a repealing statute is unconstitutional, the statute which it attempts to repeal remains in full force and effect. And where well, what did I say there? Remains in full force and effect. Is the Second Amendment in full force and effect? You better believe it. Okay? And what is it they don't understand about infringe? And where a statute which it attempts to repeal remains in full force and effect, and where a clause repealing a prior law is inserted in the act, which act is unconstitutional and void, the provision of the repeal of the prior law will usually fall with it, and will not be permitted to operate as repealing such prior law. In other words, the law stands always, the real law, the Constitution. The general principles stated above apply to the constitutions as well as to the laws of several states insofar as they are repugnant to the Constitution and the laws of the United States. And let's see if 54 will confer. Kuhn versus Berry, but I can tell you Marbury versus Madison is higher than that, but I'd be willing to bet you they cited Marbury in that. Moreover, a constitution of a statute, a construction of a statute which brings in conflict with a constitution will nullify it as effectively as if it had, in its express terms, been enacted in conflict therewith. So, anything passed in conflict with the United States Constitution is clearly unconstitutional. It doesn't take a college professor graduating magna cum laude from Harvard to figure these things out. All you have to do is read. That's why God gave you eyes now. The actual existence. Well, let's go to 257. 257, same book, 16th Jurisprudence. The actual existence of a statute prior to determination that it is unconstitutional is an operative fact and may have consequences which cannot justify being ignored. When a statute which has been in effect for some time is declared unconstitutional, questions of rights claimed to have become vested, of status, of prior determinations deemed to have finality and acted upon accordingly, of prior determinations deemed to have finality and acted upon accordingly, and of public policy in the light of the nature both of the statute and of its previous application, demand examination. All right? It has been said that an all-inclusive statement of the principle of absolute retroactive invalidity cannot be justified. Obviously, it would be ex post facto. An unconstitutional statute is not necessarily a nullity. It may have indeterminate consequences binding upon the people. All right? So you have to pay attention to what's going on. Now, let's get a few more and we're out of here. Section 258. I'm just going to read the important section here. On the other hand, it is clear that Congress cannot by authorization or ratification give the slightest effect to a state law or constitution which is in conflict with the Constitution of the United States. Does that make sense to you? In reality, it would be what? A nullity. Why? Because it's in conflict or repugnancy. It'd be in violation of Marbury versus Madison, right? Now, are you starting to see the gist of what's going on here? There's just one more, I think, and we're out of here. All right, section 260 of the same 16th Am Jurisprudence. Now, folks, head down to the law library. The books are usually green or red in color. They're kind of thick. Ask the librarian where Am Jurisprudence Second is stored. Go on over there, grab the 16th volume, start at section 1, and just start paging through to say at section 300. I'm telling you, you won't believe it. We're going to look at section 260. Although it is manifest that an unconstitutional provision in the statute is not cured because included in the same act with valid provisions, and that there are no degrees of constitutionality. In other words, it's either constitutional or it's unconstitutional. There's nothing like, it's kind of like half pregnant. There's no such thing, right? So that an act is either constitutional or it is unconstitutional, okay? So if you got statute here and most of it's constitutional and a part of it's unconstitutional, guess what? It's all unconstitutional. So what we got here is a crime bill. And we got part of it is constitutional and part of it's unconstitutional. Obviously they had no authority under the Second Amendment to fool around with the right of the people to keep and bear arms. They couldn't demand that the people not possess certain firearms. So this directly applies to this crime bill. Obviously, part of the bill is constitutional and the other part is not constitutional. So what is the end result? The whole bill is unconstitutional. Does everybody see that? Excuse me. Now I want you to start looking at these things and I want you to start hammering these guys and don't let these guys pull this kind of stuff. Hook them.
And the law is not unconstitutional from the day branded. Like you don't go to court and have to say that try to prove that this law is unlawful. When it's unconstitutional, it's unlawful from the day they enacted it. Not from the day that you come in and try to start claiming that it's unlawful, but unlawful from the day that they created that law.
Over there in counter and say, hey Charlie, let's step over here. I want to check out something here. I mean, you would if they had your wallet. Wouldn't you? Does that make sense to you? Now we're going to get into a unique argument here. For the last half hour I've been trying to hammer home the power of this book. This book right here. Okay? I'm trying to hammer home the power of this book to teach you that this is the most valuable book in your whole life. If you know what's in this book, I am telling you, you are in full possession of your American citizenship. If you don't know what's in this book, I am telling you, you're going to be a slave, subject to the whim of extrajudicial people who want to tell you what to do, when to do it, how to do it, and how high to pack it. Now, my honest philosophy to you is, as a kindness and a Christian to you, I tell you, learn this book, just like you would your...
Just a little pause, guys. Hold on.
Any rights? I love it when these guys tell me I don't have any rights. I said, well, if you believe that, let's go to court. And on the end of the day, we'll see who owns who. But I'm going to tell you right now, if you violate any of my constitutional rights, I will sue your socks off and I will attach everything you own, bank, business, and home. And I'm telling you, I'm the one your mama warned you about. So you damn well better listen. Do not violate my rights, because I will come after you, and I will take care of business, and I will do what is necessary and proper, and I will pull every stop out, and I will go dig up every nut, bolt, screw, and when it's done, you will find out you messed with the wrong American, because this American is not going to back down. Okay? Now, we're going to get into a real special argument. Now, this argument has taken almost 18 and a half years to develop, so I want you to pay attention. Excuse me a second here. This argument is a unique concept that has been honed like a razor to a very meticulous edge so that you can understand what's going on. Obviously, we have established clearly that you have a constitutional right. And obviously, we have established that you are the beneficiary of the contract. And we have established that the Constitution is a contract in writing enforceable in the court of law. And we have established that you have a right to claim specific performance on the contract. And we have established that it's supposed to be interpreted in your favor. So if you've got an honest constitutional belief, they have to listen. Now let's take that to the next step. The next step is, can a state arbitrarily and erroneously convert your right into a privilege and issue a license and a fee for it? Now, I don't know, can you see this pretty clearly? This, right here? All right, let's start with here. We're going to start walking down this sheet, okay? Murdoch versus Pennsylvania, U.S. Supreme Court. Now, when you want to go into the law library and you want to look up something, what you want to do is understand that Supreme Court is Trump, okay? That's the clearest way I can explain it to you. If you got a Supreme Court case, that trumps a district court, that trumps a court of appeals, that trumps a state court, that trumps everything. So you want to deal with Supreme Court cases as best you can. Murdoch versus Pennsylvania is a unique case. It's recorded at 319 U.S. 105. That's the 319th volume of United States Supreme Court reports on page 105. So when you go to the law library, go into U.S. reports, ask the little gal there, the little guy that's behind the counter, where is the United States Supreme Court reports? They'll tell you right where it is. You grab volume 319, you turn to page 105, and it'll give you the case of Murdoch versus Pennsylvania. Murdoch versus Pennsylvania is a real unique case. And I'm telling you to read the case. You get the case. The judge always likes to see that you're ready. And I'm going to summate basically the case briefly. Basically, it is a religious test case wherein Jehovah's Witnesses in the year of 1943 wanted their right to be able to go and preach among the public, because that is their right to evangelize, okay? In Pennsylvania, they wanted them to have a license to solicit, okay? This is basically the crux of the case. Now what happened was, the Jehovah's Witnesses claimed their First Amendment right of life, liberty, and pursuit of happiness, the right to worship and exercise their religion unencumbered, right? And of course, that's one of the mainstays that founded this country, was the religious freedom, okay? And basically the points on the case that are established are: a state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involved restrains in advance the constitutional liberties of press and religion and inevitably tends to suppress their existence. All right, let's pull that over there. Everybody see that? Okay. All right, I'll start again. A state may not impose a charge for the enjoyment of a right granted by the federal Constitution, and that a flat license tax here involved restrains in advance the constitutional liberties of the press and religion and inevitably tends to suppress the exercise thereof. That the ordinance is non-discriminatory and that it applies also to peddlers of wares and merchandise is immaterial. The liberties granted by the First Amendment are and in a preferred position. Since the privilege in question is guaranteed by the federal Constitution and exists independently of the state's authority, the inquiry as to whether the state has given something for which it cannot ask a return is irrelevant. All right? No state may convert a secured liberty into a privilege and issue a license and a fee for it. Now, a lot of people come back to me and say, well, I'm not a Jehovah's Witness, so that case doesn't apply to me. I want you to reach. I want you to understand, we're not talking about whether you're a Jehovah's Witness here. What we're talking about here is, are you an American and do you have rights? What they are talking about here is that these Jehovah's Witness people exercised their rights timely, that they had a right to worship and exercise and worship their God and evangelize as they chose, and that the state came in and arbitrarily converted that right into a privilege and issued a license and a fee for it. That is totally unconstitutional. Now, we took that case as a pioneering case, and we argued that case for all of your constitutional rights. All you need to do is keep in mind that you are an American and you have constitutional rights, number one. Number two, you have to keep in mind what right. Can you pull the right out of the Constitution? If you can pull the right out of the Constitution, and I'll give you an example. How about the right to travel freely and unencumbered, pursuant to Shriver versus Thompson, and we'll get into that. How about the right to keep and bear arms, right? Does a state have a right to require a license and a fee for the exercise of the right? And if they do, can you ignore the license and the fee? We'll get into that. Now, obviously, in this case, it's clearly established, and this is the premise of this case. No state may convert a secured liberty into a privilege, issue a license and a fee for it, and require you to have that. Otherwise, you committed a crime. That's totally 100% unconstitutional. I want that to get across real clear. Now let's jump to the next case. By the way, Murdoch,
making you have to have a driver's license. Is that the same, right? Having you have a license, registering your car, those kinds of things. What do they have to do with your stuff, right?
is recorded at 319, that's the 319 volume. U.S. Reports, page 105, we'll start the case, all right? Go read the case, though. Make sure you read the case. I don't want anybody to come up and tell me they didn't read the case, because I'm going to get on you. You're not following, that's failure to follow instructions. Okay, now, we're going to walk down the next step of this case. We took care of Murdoch here. Let's go to Shuttlesworth versus Birmingham, Alabama, which is recorded at volume 373. In the same U.S. Reports, you go to volume 373, turn to page 262. When we go to Shuttlesworth versus Birmingham, Alabama, this is another unique religious case, okay? In this case, 6 ministers were accused, of inciting to riot and otherwise create a disturbance and disturb the peace, okay? They had a sit-down. This case came down in 1962. And what happened was they said they needed to have a license to have a public gathering, okay? And what happened was it went to the Supreme Court, and the Supreme Court says, no, you don't need to have a license for the exercise of a First Amendment right to freely assemble, okay? Right, basically the gist of the case is the Negro ministers were convicted in Alabama State Court of aiding and abetting in violation of criminal trespass ordinance in Birmingham, Alabama. The only evidence against them was to the effect that they had incited 10 Negro students to engage in a sit-down demonstration at a white lunch counter. Actually, there were 6 ministers, but only 2 got charged, as a protest against the racial segregation. And they cite other cases. A lot of times you can find other cases in these cases. In Gober versus City of Birmingham, Alabama, this court today holds, on the authority of Peterson versus City of Greenville, that the convictions of those 10 students for criminal trespass were constitutionally invalid. Since those convictions have been set aside, it follows that these petitioners did not incite or aid and abet any crime, and that therefore the convictions of these petitioners must be set aside. Now basically what they were claiming is their constitutional right to freely assemble. The cities was claiming that they had to have a license to put on a demonstration, which they didn't have, and they were charging them with a criminal trespass for not having a valid license to freely assemble and or protest, okay? Now, the gist of this case, I want you to see the significance of this case in view of the case we gave you before that. Murdoch versus Pennsylvania clearly established that no state could convert a secured liberty into a privilege and issue a license and fee for it. Has everybody got that? Shuttlesworth versus Birmingham, Alabama said that if the state does convert your right into a privilege and issue a license and a fee for it, you can ignore the license and a fee and engage in the right with impunity. That means they can't punish you. They got to let you go. All right? Does everybody see that? It's very important that you understand, first, your Constitution is the supreme law of the land, and you have that right. And that right shall not be infringed, and it's supposed to be enforced in favor of you, the clearly intended and expressly designated beneficiary. It's very important that you understand that no state may convert that right into a privilege and issue a license and a fee for it. And if they do, Shuttlesworth versus Birmingham, Alabama says you can ignore the license and engage in the right with impunity. That means they can't punish you. Now, the next case is very important, and it's very important that you see the
Pro
argument.
se is the future.
Okay? That's United States versus Bishop. That's 412, volume 412.
It's not
United
enough
States
to know your
Report.
rights. It's you got to know how to defend them too in court.
Come down here. United States versus Bishop is a very unique case. Basically what Bishop does is it sets a standard for what constitutes a criminal violation in terms of willful intent, okay? Willfulness is one of the major elements that is required to be proven. In any criminal element, you have to prove, 1, that you're the party, 2, that you had a method or an opportunity to do the thing, and 3rd, that you did so with a willful intent. Now, when we get to willful intent, willful is defined as an evil motive or intent to avoid a known duty or task under the law with a moral certainty. Obviously, in the previous 2 cases, you have decided that you have relied on the United States Constitution. And and you have relied on decisions of the United States Supreme Court. So could you have willfully done any deed or crime? Obviously not. So guess what? This case stipulates that you have a perfect defense to the element of willfulness. Alright? Since the burden on the prosecution is to prove that you did willfully and knowingly avoid a known duty or task under the law with moral certainty, he cannot perform that task, can he? Because it's obviously you have a constitutional immunity to that. The previous case, Shuttlesworth versus Birmingham, Alabama, said they couldn't even punish you. The case before that said you didn't need a license for the exercise of a right. And the case before that said your constitutional right is supreme over any state law. So if they pass a law in violation of your Constitution, the Constitution overwhelms the state law. So the law doesn't even exist in law. Does everybody see that? Now, since the prosecutor does not have a cause of action for which relief can be granted, Your Honor, may it please the court, counsel is specifically precluded from performing his major task. Therefore, Your Honor, may it please the court, at this time I would motion most graciously for a dismissal with prejudice for failure to state a cause of action for which relief may be granted by this honorable court, and I'd kind of like to collect my costs and fees for having to defend this patently frivolous and spurious complaint, sir. May it please the court. Laughter will usually break out thereafter, at which point the judge will usually turn to the prosecutor and say, "Well, Mr. Gross, what do you think we ought to do about this young fella?" And he'll say, "I go for the motion to dismiss, Your Honor," and the judge will turn to him and say, "That's a good answer, because I don't think you're ready for this kid today." And 40 attorneys will break out laughing. Okay, that's actually happened to me, folks. I'm telling you, this argument is a killer argument. It's good for every single constitutional right you've got. All you have to do is fill in the blanks. What constitutional right? Prove that you have the constitutional right. Tell them the state doesn't have a right to convert that right into a privilege. Tell them that they can't even punish you if they do. And then claim that the prosecutor can't prove willfulness, so you obviously didn't do no crime, and then flip around and demand for your dismissal, which is your right, and get your costs and fees for having to defend this frivolous case, may it please the court. And I promise you, you will be amazed. 40 attorneys will jump up and say, "Yeah." They'll come up and shake your hand and tell you that's one of the most magnificent arguments they've ever heard. They'll tell you you got something like King Kong for taking on a bar association or whatever. Now, I'm telling you these things that personally happened to me. I can relate the exact cases. That goes for practicing law without a license. Obviously, you got a right to work. You got a right to contract your right to work as you see fit, not as some arbitrary and capricious bar association sees fit. Right? Doesn't that make sense to you? You don't want to belong to the union, that's your right. This is a right to work state, right? The bottom line is this. They cannot compel you to have a license or pay a fee for the exercise of your right. And if they do, you can ignore the license and a fee and engage in the right with impunity. That means they can't punish you. And since you got a perfect defense to the element of willfulness, they cannot punish you. They have to dismiss. They do not have a cause of action. Now, this argument I'm telling you has taken us over 18 years to develop in courts and in law libraries over the years, and just kind of compiling and arguing cases and doing this. This argument is a killer argument. Have they ever won against us on this argument? Nor could they in the United States of America as long as the Constitution stands. I'm asking that you pay attention to this argument and start utilizing it. We'll show you some of the techniques later in the second half, all right? Now, the word willfully has the same meaning, all right? In controlling the voluntary, intentional violation of a known legal duty. And the distinction between the statute is found in the additional misconduct that is essential to the violation of the felony provision. If they can't prove willfulness, they can't prove nada. Okay? Because everybody got that. Now, let's go to the next one. Now that you've won and your rights have been violated, the next thing they will claim, well, we acted in good faith, or well, we acted in good faith. We had good faith reliance that you broke the law. Okay? And that means you can't sue us.
Now right here he's going to show what a bunch of bull that is with the next case, right? Check this out. This is important.
That's a lie. You see, since these two cases, Owen versus City of Independence, which is recorded at 100 volume, and you want to look at Supreme Court reports, now that's a different reporter. Supreme Court reports will actually say on the back of the reporter, Supreme Court reports. It won't say U.S., it'll say Supreme Court reports. So that's a different volume. It's a newer reporter. So you want the 100th volume, and you want to look up Supreme Court reports, and you want to turn to page 1398. There is also a counterpart case to this Owen case, which is Maine versus Thibodeau. I'll give you the site for those. Okay, I gave you Owen versus City of Independence, so I'll give you Maine versus Thibodeau. Maine versus Thibodeau is recorded at 100 Supreme Court, that's 100th volume, Supreme Court Reports, page 2502. Now basically the summation of what these basic arguments say. Where plain language of a statute supported by consistent judicial interpretation is strong, it is not necessary to look beyond the words of the statute, right? Now, these are both civil rights cases. The right of action created by statute relating to deprivation under color of law, of state law, of a right secured by the Constitution and the laws of the United States encompasses claims which are based solely on statutory violations of federal law and apply to the claim that claimants had been deprived of their rights in some capacity to which they were entitled. Now, whenever this happens, folks, you must understand something. And that goes for both Maine versus Thibodeau and Owen versus City of Independence. And I'll tell you the brief synopsis on both these cases. Owen was a police chief in the town of Independence, Missouri. And he got in a gripe with the city council, and they indiscriminately fired him without just cause. Owen turned around and sued. They claimed that they acted in good faith.
Here they're talking about officers, judges, whoever having immunity, right? Do they have immunity? They don't have immunity. There's cases that try to say that they have immunity, but that's false. Owens versus Independence will say is ruled that they don't have
The
immunity.
Supreme Court said, "Sir, you are deemed to be officers of the law. You are to advise us to the law. You can hardly claim that you acted in good faith for a willful deprivation of the law, and you certainly can't claim ignorance of the law, because a citizen out here on the street can't claim ignorance of the law, and it makes the law look stupid if an officer of the court or some officer of government doesn't know the law, and then they go ahead and abuse somebody's constitutional right." So in matters of constitutional rights, both these cases uphold one point. And the point they uphold is that whenever they violate your constitutional rights, they do so at their own peril. And it even says that in Title 18 United States Code, Section 241 and 242. It says that upon conviction, you are subject to a $10,000 fine, 10 years in jail, or both, and if death results, life in prison. They're telling you, don't violate somebody's rights. Please, don't do that. Title 42 United States Code, Sections 1983, 1985, and 1986 clearly establish your right to sue anybody that does that. Now, they're going to claim you can't sue them because they have judicial immunity. Well, guess what? These two cases remove judicial immunity. There is no judicial immunity for violating somebody's constitutional rights. Judge, you are deemed to know the law and sworn to uphold it. You can hardly claim that you act in good faith for willful deprivation of the law, and you certainly can't plead ignorance of the law, for that would make the law look stupid for a knowledgeable judge to claim ignorance of the law when a citizen on the street can't claim ignorance of the law. Therefore, there is no judicial immunity. I want to get that across. I don't know how many attorneys come up to me all the time and tell me, well, they're immune because they acted in good faith. They're just not reading their court. They're not reading their court reports, because if they were reading their court reports, they would have known this case has been on the books since 1982. Both these cases came down in 1982. So I want you to pay attention to these cases. When somebody tells you they can violate your rights with impunity, you just kind of smile and say, make my day.
Now, on Owens versus Independence, it was overturned, but only because they found that they were acting in good faith, that the police officers were acting in good faith. But if they're not acting in good faith, Owens versus Independence will be upheld because, well, obviously, they should know what they're doing. They can't claim ignorance of the law, because no one can claim ignorance of the law. If the Joe Schmo on the corner of the street can't claim ignorance, oh, I didn't know, neither can they, especially if they're deemed to know the law. If they're supposed to know the law, they can't claim ignorance, and they can be acting in good faith, which will uphold Owens versus Independence.
Okay? Now, the next case we want to talk about is Briars versus United States. We mentioned it previously earlier. Briars is recorded at 273, volume 273, U.S. Reports, page 28. Okay? Now, Briars versus United States is a unique case. It's a search and seizure case, but basically it sets constitutional standards which we had talked about in the Am jurisprudence sections. Okay? I especially want to pay attention to note number 3 here. Constitutional provisions for the security of a person and property are to be liberally construed, and it is the duty of the courts to be watchful for the constitutional rights of the citizen and against any stealthy encroachment therein. All right? When a federal officer participates officially with a state official in a search, so that in substance and effect it is their joint operation, the legality of the search and the use and evidence of the things seized is to be tested in federal prosecutions, as it would be if the undertaking were exclusively the federal agent, all right? The reality here is, what they are setting is the standards must be liberally construed in favor of the citizen. It's the duty of the court to make sure that happens. So now, you have a right to be wrong. You have a right to enter your viable defenses that you honestly think. No state can convert that right into a privilege and issue a license and a fee. If they do, you can ignore the license and the fee. They must prove the burden of proof of willfulness, which they cannot do. If they do violate your rights, you do have a right to sue them in Owens v. City of Independence and Maine v. Thibodeau. They have to give every consideration to you, all right? And that's the way it is. 1900 yesterday, all right? The next case we want to talk about is Boyd. Boyd versus United States is recorded at, it's recorded at 116, volume 116, United States Reports, page 616. So everybody got that? Can you see? Bear with us, folks. We're really trying to jam here for you. Boyd versus United States, 116 U.S., page 616. The court is to protect against encroachment of constitutionality or secured liberty. All right? Now, it is equivalent to a compulsory production of papers to make the non-production of them a confession of the allegations, which is pretended they will prove. And a lot of times that happens in federal cases. They'll claim something, they won't prove it. That's happened to me, believe me. And then the fact that they've claimed it makes it true. All right? Now, excuse me. And then, of course, you have to prove a negative, which is impossible. All right? Now, the seizure or compulsory production of a man's private papers to be used in evidence against him is equivalent to compelling him to be a witness against himself in violation of the Fifth Amendment, and in a prosecution for a crime, penalty, or forfeiture is equally within the prohibition of the Fifth Amendment. See that? Now, the bottom line here is, Boyd protects against encroachment of constitutionally secured liberties. It's arguing the Fifth Amendment here, but it's basically arguing against encroachment, right? So that's one you want to pay attention to when you're coming, especially to things on search and seizure natures. Another good case that you should know is your Miranda versus Arizona. And folks, I'm going to tell you something, and even I can learn something. Not that I'm that much above you. I want to come to you humbly, in humility. I'm telling you, I've read and I know, and there's a lot of things about the law, and I've been my own attorney for over 25 years, and I kick the tail out of them, I'll be honest with you. But I always can learn something, and I'm not stupid enough ever not to realize that. And the next thing I'm going to tell you is probably one of the most important things we're going to tell you today. This is the Miranda versus Arizona decision. It's recorded at 384, volume 384 U.S., that's U.S. Reports, page 436. Now, this is a heavy-duty case. Every American should know this case backward and forward, upside down, and other. All right? Miranda versus Arizona. This is the one that says you got a right to remain silent, you got a right to an attorney, you got a right to have your attorney present during question. Anything you say can and will be held against you in a court of law. If you can't afford an attorney, one will be appointed for you by the court. Do you wish to make any statement on your behalf? Do you understand the rights that I have spoken to you? As soon as they stop you, talk to you, as soon as they start talking to you, they are required to say that. If they don't say that, they screwed up. If they haul you into jail and they don't tell you this, read it to you, and then they want to make you sign a little statement that you know your rights and you knowingly waive them, please, folks, don't sign that statement. Here's your head for something other than a hat rack. Do not sign that statement, ever. You are knowingly waiving your constitutional rights. Don't ever do that. I mean, they don't make it that hard. As soon as you hear those people start talking it, you tell them right effectively, I want to talk to an attorney. And I'm not saying nothing until I talk to an attorney, especially if you're talking to federal people, BATF. These people will lie, cheat, steal. They will do anything they can to hammer you. Their whole purpose in life is to hammer you. I don't want you to think, oh, what nice guys, so maybe we can just work this out. Why don't we just talk and maybe we can get things worked out? You don't talk to these people, folks, and you're talking to somebody who learned the hard way. You do not talk to these people ever. I don't care if you think you're a nice guy and you want to be courteous. I don't think you think if you're going to work it out. I don't think you think if you're smarter than they are, you can beat them. I'm telling you, you don't talk to them, period. You button that hatch. An old wise legal defense counsel told me one time, he said, the first rule is keep your big mouth shut. I said, okay, what's the second rule? Keep your big mouth shut. He said, what's the third rule? Keep your big mouth shut. He said, after you follow them 3 rules, the rest is easy. It's when you open your big mouth that you get in trouble. Not that you would do anything wrong anyway, but they'll twist, lie, cheat, and steal and make it into something you didn't do, and before you know it, you won't even recognize what's happened. And I'm telling you, it's happened to me. So I'm telling you as a friend. I'm not telling you as a smart ass or anything else. I'm telling you as a friend. Do not talk to these people. They do not have your best interest at heart. And you may think, well, they're the government, and they're responsible, and they mean well. Well, they don't. They don't mean well. They don't mean you're well. And they will jam you, believe me. And if you're not real good at getting out of it, you can be in a lot of trouble. All right, now, let's look at this Miranda decision. In the absence of other effective measures, the following procedures to safeguard the Fifth Amendment privileges must be observed. The person in custody must, prior to interrogation, be clearly informed that he has a right to remain silent, and that anything he says will be used against him in a court of law. He must be clearly
Good to
informed
see you in
that
the
he
chat
has a
too,
right
Mile
to
High.
consult with a lawyer.
Good
And
to
he
see you,
should have
Howie.
a lawyer with him during interrogation. Do that, please.
You too, Joe
And
Martinez.
that
Thanks
if
for
he is
showing up.
indigent, a lawyer will be appointed to represent him. All right. If the individual indicates prior to and during questioning that he wishes to remain silent, the interrogation must cease. If he states that he wants an attorney, the questioning must cease until an attorney is present. Where an interrogation is conducted without the presence of an attorney and a statement is taken, a heavy burden rests on the government to demonstrate that the defendant knowingly and intelligently waived his constitutional counsel right. Don't test that theory. But I'm telling you, it works. I did it. Where the individual answers some questions during interrogation or custody interrogation, he has not waived his privilege and may invoke his right to remain silent thereafter. The warnings require that the waiver needed are, in the absence of a fully effective equivalent prerequisite to the admission or admissibility of any statement, inculpability or exculpability made by the defendant. The limitations on the interrogation process required for the protection of the individual's constitutional rights should not cause an undue interference with the proper system of law enforcement, as demonstrated by the procedures of the FBI and the safeguards afforded to other jurisdictions. In each of these cases, the statements were obtained under circumstances that did not meet constitutional standards for protection of the privilege against self-incrimination. Now, this is the big one, folks. This is the one they're talking about. Did you properly Mirandize him? Was he Mirandized? Was she Mirandized? If they don't Mirandize you, you got to throw the case out. Almost always. It's very hard to go forward with the case if their witnesses are excludable from the presentation of the case.
Alright guys, I think that's about long enough. Those of you that are still here, I hope you guys got something out of this. There's a lot of good information in here. The American Jurisprudence books. He talks about American jurisprudence if you go back in the video. There's a lot of good information, guys, on pro se. He's a pro se litigant himself and a former veteran too. A lot of good information that I think anybody can use, maybe somehow, some way, maybe sometime, I don't know. But maybe you can get your lawyer to look up some of these cases and use them for your benefit and to help you out. Alright, guys? And well, that was for the record. I hope you guys liked it and got something out of it. It's good, a good video.